What's up, everybody? Welcome back into an episode of the Lawyer You Know podcast. And on today's episode, we are going to take a look at a bunch of documents that I had never seen before. I got a bit of a document dump from Marbury versus Mad. So thank you for continuing doing God's work. And we're going to get my dad's thoughts on not only the new documents, but also some of the other stuff we've already talked about that you guys said you wanted his opinion on what Commissioner Cox had to say in response to Alan Jackson and the whole Dever situation, in response to the GPSs on the cars with the kill switch and all of the Proctor information that's being sent out to all these other cases, including cases that are still awaiting trial. But we're also going to get his take on what could this mean for the cases that have already concluded, where people are literally sitting in prison because of Michael Proctor's work. Are there going to be guilty people that are freed? Are there going to be innocent people sitting in prison that maybe we'll find out about now that we have all of Michael Proctor's personal phone data? We'll get his thoughts, his feelings on all of that, and answer so many questions you guys had for Big George coming up right now. So we are both right now in Tallahassee. We just came off another big FSU basketball win, another game in a row. We're scoring 100 points. Luke Laux is crushing it as our coach. We had a great time at the game last night, Dad. And now we get to sit here and talk about the Karen Reed situation, do a podcast together. What's better than that, right?
Oh, life is good.
Yep. So last week I did 2 videos on new information coming out. We'll call it the Karen Reed situation, but now it's kind of the Commonwealth, the state of Massachusetts as a whole. It feels like there's so many cases that are being touched and affected by so many things that have come out since Karen Reed, and just, this ripple effect of the dropping whatever it was in the water, and now it is expanding out and touching so many more cases and so many more people than maybe we could have imagined at the beginning. But when we talk about Massachusetts as a whole, and you talk about the boss cop in Massachusetts, and Commissioner Cox was called out by Alan Jackson because of comments that he made saying, I didn't know Dever was involved with Karen Reed. We didn't talk about it. After Dever at trial said we absolutely did talk about it. Then there are emails confirming that. It certainly seems like they met. It certainly seems like they talked about this case. And when he was pushed on it even more, and Alan Jackson wrote another scathing letter basically saying we need to do something about it. The state of Massachusetts needs to do something about what Michael Cox did and said. Here was Michael Cox's response.
The commissioner had to say that you won't hear on any other station.
But what I need, it's not to be asked this question ever again, because it hasn't pertained anything to do with the police department. My condolences to the O'Keefe family for, what they've gone through, and because we did lose the department member. But outside of that, this has nothing to do with us, and I'm not going to be doing this again.
So that was it. I need to not be asked about this again. It has nothing to do with us. It has nothing to do with the police. My condolences to the O'Keefe family. What did you think about that response?
Well, it's absurd that the chief law enforcement officer of that area, Boston is not a small police department. It's one of the largest in the country. He's the commissioner of Boston, so it's a huge job. The buck stops with him. So I tell you, frankly, it's incompetent if he didn't know about it. He's incompetent if he, come on. It was in the paper every day. You've appeared on TV shows in Boston about the case. Doesn't he watch TV? Doesn't he keep up with what's going on in criminal trials where his people are witnesses or his people are getting embarrassed? No, it's absurd that he said that. And I think, frankly, it's been proven to be untruthful by the emails or text messages that we've seen in the past. So I just don't believe the guy, and he's put his head in the stand. And he's trying to avoid embarrassment. Frankly, I wouldn't trust him with anything.
I have spoken to some high-ranking local law enforcement in Florida and FBI agents nationwide, ATF agents, federal agents all over the country that are aware of this case, that are aware of Karen Reed, that are aware of Ms. Dever. And it's like for him to act like, oh, I've never said those 2 words together. I had no idea that, anybody in my department, how many people I've had reach out and be like, this person who knows this person who knows this person had something to do with the Karen Reed case. And I'm supposed to believe that this guy didn't know that Kelly Dever had something to do with the Karen Reed case. I mean, that's just unbelievable to me. And I think it says it all that he said, what Commissioner Cox needs is to never be asked this question again. That's what he wants. That's what he needs. And that says a lot, in my opinion.
Well, just think about the people that are under him. If he's got people that are under him that are not keeping him informed about the Karen Reed case or what's going on in the Karen Reed case, or didn't talk to him about the fact, hey, look, we're looking to hire, I don't want to mispronounce her name.
Dever.
Dever?
Dever.
Dever.
It's a shocker. The 50-50 chance you were probably going to get it right.
I know. But if he's got people under him that don't come to him and say, hey, look, we're going to hire this person from the Canton Police Department, and there's some scandals going on there, then he needs to fire those people too, because they're not doing their job.
Yeah, I don't think that's quite how it went down, but
Well,
remains to be seen if we hear any
so.
more about this, or if the people give him what he wants and just don't ask him that question again, because that's what he needs. So many more things coming out, and some of them bombshells, some of them not. A lot of people want to read into a lot of what's happening, but we're going to talk through some of the documents found that confirm some things that I think are important. Do they prove corruption? Do they prove cover-ups? Do they prove scandal? I'm not so sure, but I'm going to run some of these by you as well, and we'll kind of discuss them together. The first is that Brian Tully, who, for all intents and purposes, reports have come out that he is going to be one of the defendants Karen Reed sues for violating her civil rights. And maybe some people have questions why. We'll talk about that. But a few of the documents I found were interesting, in a huge hundreds and hundreds of documents that have been requested from FOIA requests. Talk about how he seemed to be pulling the strings. His fingerprints seemed to be on everything. He was talking to all the different witnesses. He was helping prep the witnesses. He was telling them what to do, telling them what they were testifying to. Even Jessica Hyde, who was the cell phone expert for the Commonwealth, he was corresponding with her. So we're going to just take a look at a couple documents here together and kind of break down how important this is, how surprising this is, if at all. And here is the first one. So this is an email from Brian Tully. And who is he writing it to? But Michael Proctor, Yuri Buchanan, Nicholas Guarino, Matthew Dunn, Christopher Moore, David DeChico, Connor Keefe, Zachary Clay. He copied John Fanning on it, who, again, John Fanning has nothing to do with this. He has nothing to do with this case. That's a lot of what they said. And the email says, I spoke with Adam. That's referring to Adam Lally, I assume, the assistant district attorney's trying the case for the Commonwealth, and reviewed what everyone will testify to. You will each have time to sit down one-on-one to go over the specifics, but this is what we talked about. So this is before Lally has prepped the witnesses, and a lot of these witnesses, I think, said Tully was in the room when they were prepped, but this is before the prep. It says Proctor will testify to CF McCarthy's and Waterfall video, receipts, and defendant's alcohol consumption. Oh, he testified to so much more. Nick Guarino would testify to Celebrite and the O'Keefe's GPS. Yuri Buchanan, the clothing from the hospital, CPD Sallyport video, thumb drives on your desk, video from Dighton at defendant's parents' house. Tully will testify to CSLI, Canton Library and Temple video, Boston Magazine interview, physical evidence from the scene. A couple other things that occurred to me that we are missing: tail light pieces and hat found on subsequent days, and ring at John's house. I will get with Adam on those items. Let me know if I'm missing anything. If your name doesn't appear above, continue to review any reports you wrote. And this was on April 29th of 2024. And then there's other emails that says you're receiving this email because your name appears in the Commonwealth's witness list for the Karen Reed trial, except Lieutenant Fanning. He is not, but we know, he had nothing to do with the case, right? Please start to review all material now, including reading over your notes and reports. I do not want anyone to be unprepared come trial. That is from Brian Tully. So what is your initial reaction when you see these emails?
First off, not unusual. He's a lieutenant. He's the one to making sure coordinating all his people, that they're all available. He talked to Adam, and Adam is organizing the case. These are the pieces of the case. Some pieces are missing. He needs to get those pieces done. There's a couple of things here. One is, this is not that unusual, a leadership role that this lieutenant is taking. What is unusual is we don't know if this was turned over to the defense, because I think this is definitely discoverable. It's definitely something the defense can use in cross-examination, but it's people, when you hide it, you make it look worse. than if you just came out and talked about it. So again, this is not unusual. He's taking a leadership role in coordinating his officers.
So I'm probably going to spoil a lot of the episode here, but so much of what I thought when I read this is under normal circumstances with good cops who understand their job and what they're doing, who know how to testify on the stand. A lot of this is not that big of a deal. Totally could
Right.
take the stand and say, yeah, I was in charge. These are my guys. I'm responsible for what they do. So yes, I'm going to talk to them. I'm going to prepare them. I checked their reports to make sure everything was, all the I's were dotted and T's were crossed because that's my job. And if not, it's a teachable moment. If they did something wrong, I'll teach them. We'll explain it to them. And then I come here and we explain to the jury, but our job is the investigation. It's not that hard to explain this away.
No.
But it is important when they try to argue that Fanning has nothing to do with the case and has no involvement, and then he's copied on these emails. I find that to be troubling, number one. Number two, were these turned over, like you said? Because like so many other documents, this is important. This is Brady. This goes to the credibility. Were they testing each other? Were they getting their quote unquote story straight? And then we also have to realize the context of the Karen Reed case. These are not normal cops. This is not a normal investigation. There is some smoke here. And because there's some smoke, the defense has the absolute right to say, see, look, you didn't know how you were going to deal with those taillight pieces or that hat, did you? You didn't even know who was going to testify about it because you guys don't know how it got there, did you? Those types of questions are fair game, in my opinion, as a defense attorney. If I'm looking at this email, then I'm like, some of this was real cut and dry. Who's testifying to what? But when it came to the taillight pieces, you guys didn't know how you were going to handle that because how did they get there? How did they get on scene? You knew Proctor couldn't testify to him because he planted them there. Whatever you want to do, this email does add to the cross-examination of multiple law enforcement witnesses in this case.
Well, you also have this, I'll be honest with you. This happens a lot, but it's not in writing.
Exactly.
This lieutenant should be going to these guys and talking to them and not putting this stuff in writing. When you put it in writing, you memorialize it and it makes it part of discovery. But yeah, like I said, this is not an unusual conversation for a supervisor to have with the people he's supervising, but to put it in writing, that was just foolish.
Yeah, I agree. I completely agree. Okay, let's look at the next one. 681 here. I'm going to be moving documents kind of around. All right, here's the next one. This one is also from Brian Tully, and it's to Proctor and Buchanan. And it says defense witness list, and it says start researching who these people are. And I saw some posts on this on Twitter, and people are like, oh, look, here we go, here we go. What did you think when you saw this?
Again, not unusual that you should look at the backgrounds of the witnesses because you want to give the prosecutors what you can give them for cross-examination of the defense witnesses. That's part of law enforcement's job, is to do an investigation. Who are these defense witnesses? What are their backgrounds? Can we show any bias or prejudice in their testimony by, their backgrounds or where they came? Who are their friends? Again, this is not unusual. This happens in every case, or it should happen in every case, so that the prosecutor has as much ammunition as he has for cross-examination. Again, with over and over, I'm going to say this, I'm sure. The key is here, were these turned over? And if they weren't, why wasn't this turned over?
So the first thing I think of is every prosecutor's office is a little bit different. Some do it more in-house or have investigators. Some use law enforcement for it. Some might do it themselves. But when we talk about the fact that they're researching defense witness, that doesn't bother me. That's no big deal. The way they're researching them obviously is important. And the fact, again, if you're saying, oh, these are dirty cops and bad cops, and they're looking for information to intimidate them, maybe Turtle Boy wants to look at this email and be like, look, that's all I was doing was researching the witnesses, right? And discussing what I found. But they also can find, have they ever been convicted of a felony or a crime of moral turpitude? And they have access to documents that, maybe some normal people don't, to be able to find out information that might actually be relevant when it comes to these witnesses. So under normal circumstances, if these are good cops, this is no big deal. Under these circumstances, maybe it adds a little bit more to the smoke. Okay, so if you were looking at this from the perspective of a civil attorney looking at the 1983 action, and you hear Brian Tully might be involved, do you think these emails, and there's more than this, again, he's talking to the Commonwealth expert, Jessica Hyde, Do you think there's enough in here to show that he was, I don't know if the puppet master is the right word, but the boss, the supervisor, had his fingerprints on this case? And another reason why maybe a no law enforcement officer, including Brian Tolley, wants to take the stand and say, these are my guys, these are my gals. I teach them how to do. I'm responsible for what they do. That's why I'm writing these emails. I can understand why a lot of people don't want to do that, would rather wash their hands of this case like Michael Cox is trying to do. But do you think these emails show enough involvement where the buck kind of stopped with him on this case, with this investigation, what they did, the testimony, and this is going to be part of that 1983 action?
If you live in Connecticut, Michigan, New Jersey, Pennsylvania, or West Virginia, and you like casino games, you're going to love today's sponsor, DraftKings Casino, the home of cash eruption. You can spin the largest collection of cash eruption slots, including new and exclusive big bank breakouts. New players get 500 spins over 10 days on your choice of cash eruption slots when you wager $5. Play classic cash eruption today, then Red Hot Joker or Coins and Clovers tomorrow. It's all up to you. Get the app, sign up with code LAWYER, then start spinning on the home of cash eruption. In partnership with DraftKings Casino, the crown is yours. If you have a gambling problem, seriously, please call 1-800-GAMBLER. In Connecticut, help is available for problem gambling. Call 888-789-7777 or visit ccpg.org. Please play responsibly. You have to be 21 plus and physically present in Connecticut, Michigan, New Jersey, Pennsylvania, and West Virginia only. Void in Ontario. Eligibility restrictions apply. Non-withdrawable casino spends issued as 50 spins per day for 10 days. Valid for featured game only and expire each day after 24 hours. See terms at casino.draftkings.com/promos. Ends January 4th, 2026 at 11:59 p.m. Eastern Time.
Well, it all depends on the spin. There's two ways to spin this one sentence here. One is, again, Tully, puppet master. I am coordinating everything. I am making sure everything goes through my fingers before it goes out. And so that's the puppet master. So let's bring the puppet master in because he controlled everything that was going on in this. The other side, the defense side, is going to say he was doing a normal lieutenant function. He was doing what he's supposed to do, and it was nothing special. It was nothing negative about it, that this is just what they're supposed to do. And then they would bring in an expert who was some law enforcement captain from someplace else to say, this is all normal stuff. This is what he's supposed to do. So you can't assign anything nefarious to the fact that he's doing this. So it's all going to depend on what the spin is that the jury is going to buy in the civil case. But there's enough here to bring Tully in the civil case. Absolutely.
Yeah, and it sounds like, again, he's going to be. But the next document I want to talk about is, this one I found interesting. And I think we maybe disagree about this one a little bit, but I think it more has to do with just the fact that it's this case. And I'm looking at these emails through the lens of this case. But this is an email from Connor Keefe to Michael Proctor. It says, Waterfall and CF video reports. Mike, take a look at these reports and let me know if you need me to edit anything. So what are your first thoughts when you look at them as just kind of like a general normal case lens?
All right. Every supervisor looks at reports and, in fact, tells people to edit reports. You don't edit it for the substance of the report, but maybe the way it's worded or maybe how you did a phrase, those kinds of things. But you don't change the facts. You don't change the substance. And so, again, this is going to be the spin that's put on it. Is the word edit means that he wants him to change the facts of the case? Does he want him to point the finger at somebody in particular? Or does edit just means, grammatical errors and those kind of things that he wants to correct? And that's what edit should be, that a supervisor shouldn't be telling somebody to change the facts or to change his report. Again, it's going to be how the jury takes the spin on that word edit.
Yeah, to me, once again, we have to remember what the actual context of this case was, where they try to act like Michael Proctor was not, a supervisor or the lead investigator in this case. He wasn't really doing much of this. It was Yuri Buchanan and all this stuff. It's like, Yuri Buchanan is not on this email. There are officers asking Michael Proctor if they should edit reports. Obviously, they can put the spin on, oh, look, Proctor was editing all these reports, whatever. I'm not saying that is necessarily true, but the control he asserted over this case is very obvious through these emails. The emails Proctor writes to other people. It's very obvious. And I don't know if they had these emails or not. Again, that's such a big unanswerable question for me at this point. I guess I could ask them and see, what they say, but there's 800 documents. So it's hard for them to probably say whether they had one or the other. But if you did have this, it's pretty easily provable. Michael Proctor had a lot of control in this investigation. And
No, go ahead. No, finish. I thought you done?
Go ahead.
Okay. Well, I think we know from the trial. I mean, the testimony at trial was very clear about Proctor's involvement. The state tried to minimize his involvement, but they just couldn't. The defense just brought it out over and over again how Proctor has tremendous control over the investigation, what was happening, how it was happening, the quote word lead investigator, those kinds of things. So I think the trial, again, the civil trial is going to be, I'm sure, have the same testimony as the criminal trial, is going to bring out that Proctor was, had a lot of control.
Yeah, and I think that's obvious, but they still tried to downplay it.
Right.
Then there were another couple more resignations. Chief Berkowitz's son resigned recently. One of the ADAs resigned recently. Do you think this is something that there's going to be more of this in the future, that these officers are resigning? We're going to talk about Sergeant Goode, who is under investigation. That's not who I'm talking about yet. But just the resignations, the reassignments to other departments, do you think that's something to continue with the aftermath of everything that's happening here with these documents being released?
Oh, I think so. Because there's several reasons why people can resign. You might have the ethical reason where people say, look, I don't want to be associated with a department like this, or I can't work under these circumstances where you can't trust what a report says or what the testimony of one of your officers is. So you resign for ethical reasons. And the other is you resign to protect yourself from an investigation, so that you can walk away quietly, and hopefully nobody will look at you and no one will care who you are or what you did once you're gone. So, there's two types of people that are resigning. I can't tell you which is which on these people, but there could be some ethical people in there too.
Right, exactly. Some of the people that are resigning, we should highlight their name as doing the right thing. We don't
Mhm.
necessarily know, but it's not a good look overall. So then there's another section here. So before we get to this section, because we're going to start to touch on Proctor with this next one, but it was pretty clear throughout these documents that Tully and Adam Lally and a lot of these emails are like, hey, grand jury is today, or the trial's today, or we need your written notes. There's a deadline. It was clear they knew about these deadlines, yet they continued to miss them. They continued to turn over things late or not turn over things at all throughout the case. How different would this look if this information is coming out post-trial, if Karen Reed was convicted, and we find all these emails, all these credibility issues, all this potential Brady material? Do you think that this would potentially create a situation where there would be enough to reverse this case and have a new trial, even if she was convicted?
I think so. If none of this was turned over, I think so, because again, the burden is that this is so egregious that it could affect the verdict. And so the judge is going to have to say, well, this is just not an isolated one email that says, I'll edit your reports. If you have a series of things that wasn't turned over in a good enough volume, where the cross-examination of so many witnesses would have been changed or altered, then how can the judge say it couldn't affect the jury's verdict? So again, that's the burden. Is there enough here that it could have affected the jury's verdict? And to draw doubt on whether the jury's verdict was credible, then that is a new trial.
Yeah, and it's just continuing to come out. And by the way, these aren't lawyers looking for this stuff that are paid for by Karen Reed to come up with her appellate brief. If those lawyers were looking at this, I bet you they'd find so much more than everybody else out there that's just kind of scanning through it and looking through it, because they'd have the trial transcript lined up. Who said what, when, what did we know, when, did we have this document or that document? Did they try to hide something as a needle in a haystack? Because a lot of times appellate lawyers can find things like that. Okay, next section is between Trooper Paul, who did the accident reconstruction in the first trial, and Michael Proctor. Paul writes Proctor and says, here's a copy of a warrant I wrote for a pedestrian crash. They're just kind of like getting their ducks in a row. Proctor then writes Paul an email that says, Joe, is there anything I can pass along to the director at the medical examinations office regarding the scene? She was looking for landmarks, where the body was located, etc. I know you mapped it. And if that is completed, can you send me something showing everything? That would be great. And then another email from Paul to Proctor. He was found along the left side of the front yard of 34 Fairview, and he was closer to the road. The area he would have landed was grass with possibly snow there. Just interesting, these details that are here. My diagram has not been completed yet. I can send it to you when I'm done. Does that answer their question? The doctor wants to physically see something so she can make a determination on accidental or homicide. Okay, this is in March of 22, by the way. And Paul said to Proctor, do you have copies of Canton PD's report? Did they take photos at the time of the initial call? Or did the crime scene come out? I'm going to start my report, and it looks like they want me to do a full report, and it would be good to go over that stuff. To me, this is showing, and there's another document I want to read here too, but to me, this is showing that they're not feeling great about it. The documentation's not great, but what they're really trying to do is get information to the ME to try and prove that this was a homicide and not accidental. And we know, with hindsight, they were not able to do that. Here is an email from Jeannie Hatch to Proctor, and it includes Scorty Bello on all of these, the ME. Good afternoon, Proctor. Can you please send a copy of the crash reconstruction report for Dr. Scorty Bello to review? Also, are you able to send us scene photos? Are you able to get Dr. Scorty Bello access to the scene photos on this case? Thank you. And then Proctor says, good afternoon. I'll be sending a second email with scene photos. Please call me so I can assist in explaining this photos and video. So Proctor, really by email and by phone, trying to convince them that this was a homicide and not an accident. Then Scorty Bello writes an email to Jeannie Hatch. I spoke to Proctor at length on Thursday. And again, this is March 15th of 22. I spoke to Proctor at length on Thursday regarding their investigation and findings from the reconstruction of the events. Can you please follow up to see if they have anything for us in writing underlined in terms of the reconstruction and evidence gathered at the scene? Does it sound like she doesn't really trust what they're talking about? Jeannie Hatch says, hi, Mike, can you forward us the updated investigative report, including the reconstruction and evidence collected? And this is March 15th of 22. So what did you take from these back and forths between Proctor and Trooper Paul, and then the ME kind of getting involved, trying to figure out if this was an accident or a reconstruction? Or a homicide?
Well, first of all, what the ME is asking for, totally legitimate. She's doing an investigation. That's part of her job. And what people don't understand, there's a difference between an ME and just a doctor examining a corpse. An ME can take facts of the investigation and make a determination from those facts and looking at the body as to what the cause of death was. It's not strictly looking at the body. It's not strictly science, but she's half investigator, half scientist. So she has to look at the investigation and see if it fits the facts of the science that she's looking at. And that's what she was trying to do here. And what she's having trouble getting, and we know that the reason she was having trouble because it didn't exist. What she's having trouble getting is the exact positioning of where everything was. Remember, if I remember right from the trial, they moved the body. So no one really knows exactly where the body was before they moved the body. And they never really did any kind of diagrams or photographs that really showed exactly where it was. People were talking generally about where the body was, but never really knew exactly where it was. So she's trying. And the other is she's doing this in writing because she has to justify everything that she does. She knows she's going to be called as a witness. And she knows that she's going to be called as a witness. She's got to be able to point to things on reports or point to things in her examination that justify what it is her conclusion was. And we know what her conclusion was, and it wasn't the conclusion that everybody wanted. I think you and I have talked about this before. I kind of thought that was the nail in the coffin of the case when she couldn't come up with the conclusion they wanted.
Right. The undetermined was
right.
Even after one side presented her with everything they wanted, it was still undetermined. And from my perspective, like this, so they did make this argument, right? That Proctor and his buddies, there were some text messages and they tried to convince her. You couldn't even get her to say it was homicide. There was discussion of that in the trial, but this to me, as a lawyer looking at it, is even better than that, because the medical examiner frankly did what the prosecutor should have done. It's like, you guys don't have enough for me to make my determination. I can't even determine that this was a homicide, let alone prove to a jury beyond a reasonable doubt. She had the same questions that a lot of people in the public had, the same questions I think the jury probably had at the end of the day. This investigation was bad on March 15th of 2022, and this medical examiner knew it. Now, the prosecutors decided to just forge ahead. Law enforcement, is this why we continued to find more and more taillight pieces? Because they're like, we can't even convince the medical examiner that this was a homicide. How are we ever going to convince a jury? Well, I know how. Let's smash the taillight and drop a few more out there. I don't know that that's what happened, but you can understand why maybe they were starting to freak out. Like, we don't have enough to prove this case. And even if, they didn't do something to John O'Keefe or leave his body there, but we've seen law enforcement in the past press and do things and plant evidence and do things horribly because they really think they're getting the bad guy. And it can start out being like, we know she did it. I just know it in my gut because I'm a cop and I know these things. I have a sixth sense and we need to make sure we get her. It could have started out like that. And when you see emails like this and you see the fact that they're all working together without any defense attorneys, right? There's nobody poking holes. There's no other opposition. There's no other witness that's going to hurt them that's talking to Dr. Scortibello. There's nobody like, well, Dr. Scortibello, look at this or look at that. It's just Proctor and Paul and everybody working together to try to get her to come up with this homicide determination, and she can't do it. It's undetermined at the end of the day. And these emails to me, I would have used these in crossing Michael Proctor. I would have used these emails in directing or crossing Scortibello. Like, you talked to Proctor 5 emails, a phone call at length. You spoke to him at length, but you wanted it in writing, didn't you? And I think that's interesting too, that she wanted it in writing. What does that make you think? How was Proctor acting on the phone for somebody? What is it whenever I have somebody and I got to follow up and be like, I need this in writing? That's because I don't believe what you just said on the phone, or I can't trust what you just said on the phone, or I need more of a guarantee. Let's put it in black and white. And black and white is what rules the day, not the conversation we had on the phone.
I did it, everyone. Secured the green corduroy pants from Quince, our sponsor for today's video. And I absolutely love them. And I can feel great about buying them because not only is the price incredibly reasonable, by partnering directly with ethical factories and top artisans, they cut out the middleman to deliver premium quality at half the cost of other high-end brands. So you can get luxury quality pieces without the luxury price tag. And you can get them for yourself, or of course, holiday season's upon us, buy it for somebody else. And speaking of that holiday season, my wife liked the green corduroy pants so much. Guess what our entire theme is for our family Christmas card picture this year? You will be seeing it on social media, and I will be wearing my green corduroy pants from Quince. That's how much our family likes it. So give and get timeless holiday staples that last this season with Quince. Go to quince.com/LYK for free shipping on your order and 365-day returns. We have had to return something, and that 365-day return is awesome. Now available in Canada too. That's QUINCE.com/LYK for free shipping and 365-day returns. Quince.com/LYK.
And also, when you talk about the cross-examination, how this was ripe for cross-examination, how great this would be for cross, it was also good, like you said, for the direct of Bello. When you went to her, it says, was it March 15th? On March 15th, you were begging them to give you something. You were begging. I mean, you weren't just saying that this, undetermined. You were trying to determine if this was a homicide or not, and they weren't giving you what you wanted, and they wouldn't give you what you wanted. And in fact, they did. You wanted it, like you said, in writing, and they didn't give that to you. What does that tell you, Doctor? I think she was a doctor, right? Dr. Bello.
Yeah,
What does this
Scortibello.
tell you?
Yeah.
Yeah. What does this tell you, Dr. Bello, about the scope of that investigation, the accuracy investigation? How many homicides have you investigated? 10,000, whatever her number was. And yet you're sitting here begging these people for stuff and they won't give it to you. How often does that happen where you beg people for stuff and they don't give it to you? Or how often do you ask for it in writing? Is it, is that your standard practice, or was this an unusual situation? There are a lot of questions that could have been asked if they had these emails.
Yeah, absolutely. And it just would have driven the point home further, I think. And again, the ultimate question is, did they have these emails? Which we don't necessarily know the answer to that. Okay, so let's transfer more into the Proctor section. We still have a couple more documents we haven't seen yet, but the first thing I wanted to ask you about was this whole GPS on the squad cars
Mhm.
with the kill switch that Ted Daniels reported on. And first off, what did you think about the reasons why they got the GPS on the cars? Is that unusual in response to a scandal? Um, and then is it normal to have kill switches? How are they abused? Just kind of your thoughts on that.
Well, first off, it's not unusual. It's happening more and more where they're having GPS on law enforcement vehicles. That's a growing trend, and it's a growing trend because of the things they suspect because of the scandal and the investigation, because they want to make sure the cars are being used properly, that they're in the locations where the officers say they're being located. A lot of people accuse officers of a lot of things, and it would be nice to say, look, they weren't even in that neighborhood, or they weren't there, or the engine wasn't running. There's all sorts of things that it just got. In other words, this backs up an honest cop. Having that GPS backs up an honest cop, so that it's just not he said, she said. If someone's accusing him of something, there's some empirical evidence here that he was at a certain place at a certain time. So I don't think there's anything wrong with it. I do. It's kind of like body cams. It's the same kind of thing. I do wonder about the fact that they can shut off body cams, because sometimes there's some evidence things happen, and you go, well, what about the body cam? You go, well, the body cam wasn't running, or we had the body cam shut off. This GPS is the same thing. It's kind of suspicious if you have it shut off at a certain time when obviously it should have been on. And in this case, it should have been on, because there were some things going on that it would have been nice for the defense to have as to locations. And I know you have better recollection than I do about how the GPS would have helped determine locations and what happened and when it happened. So it's very suspicious that it was turned off. But I also think that the GPS is a very good tool for law enforcement, and anything that makes law enforcement activity transparent is a good tool. And that's what a GPS would do.
Yeah, I mean, I definitely think it's a good tool, but when you can turn off body worn cameras, first off, there's only very specific reasons that you can do it. If you're talking about something confidential, or you don't choose like, oh, this isn't a relevant conversation, so I'm going to turn it off. Cops don't make that determination, and it should be the same thing with this GPS. And you get hammered for that. You get cross-examined for that. It's not easy for you when people are talking about, why'd you turn off this body cam? This GPS on the car should be the same way. And to me, it's obvious. And, I know we want people to do the right thing and make the right decision, so we can't use their post-remedial measures against them at trial. But now they've implemented a way where you have to log the reason why you turned it off and things like that. As a defense attorney, if you had a situation like this where there were cars with GPS on them and a kill switch, and they used that kill switch, how effective do you think that is on cross for the jury to make it look like something shady is going on if the timing lines up? Where, like in a case like this, let's say, I don't know the answer to this, but let's say Proctor had GPS on his car and it was just turned off the whole time when all these taillight pieces are being found in the yard. Like, how can you create the fact that there's some doubt? Because we could have just located exactly where your car was. Just like if you guys would have recorded these witness interviews, the he said, she said, where they're like, oh, that's not what happened, what Proctor wrote in the report, we'd be able to completely get rid of that. But because you didn't use the body worn cameras you have, or you didn't record these interviews like you were supposed to, or you didn't use the GPS on your car like you have, now there's doubt. And how does that work as a defense attorney?
Well, you've got to build the case for the jury. First off, how significant was the cam or the GPS being turned off at a particular evidentiary relevant time? So, like I said, the piece of the taillight. That's really important. So that's an issue that's really important. So number one, the significance of the timing of turning it off. The other is the habit of turning it off. How many times do they turn it off? When do they turn it off? So you create a scenario of what the habit was of this particular law enforcement officer to turn this off at relevant times. And then you have a particular time where something was really significant and he turned it off. So that's the way you destroy. You destroy them in two different ways: the significance of the time and how many times. And that's important to get a history of what this officer does. My guess is the GPS will tell you when it's turned off and turned on. My guess is there's some kind of record within the GPS system that does that. The other is, and I guess everybody doesn't really realize this till they have to pay for it, how expensive it is to maintain the record of the GPS, of body cams, because they have to have a huge data processing. Uh, 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 I'm saying
Yeah, to save them, to keep
to
them
save,
and to
right, to
save
save,
them.
right,
Yeah.
right, to save it. I mean, it's huge. It's tremendously expensive. And so, but it's there and it's available, and defense lawyers should have access to it when it's relevant. So, like I said, there's two parts to damaging the credibility of the witness when you're cross-examining them about when they turned it off.
Yeah, and I think that these lawyers would have had a heyday with it if they had all this information and if Proctor's car had it on it, right? We don't know about the timing exactly of how it worked with this, but we know I mean, even just what Ted Daniel put out in his story, about the issues about some of the days with Proctor, to me, goes against his credibility. That's how he works as a law enforcement agent. He is doing things that are shady. And again, I think that's Brady. Once again, it's exculpatory potentially. It hits the credibility of Proctor as if they needed any more of that. But I do think it's really important. There have
Well,
also been, or go ahead, you had something else?
one other thing too is, um, don't they have some cars with GPS and some cars
Correct.
without
No, no, no,
GPS?
no, no. Well, yes, but I think what you're looking for is they had a limited number of cars that had the kill switch.
Oh, I thought they had. I don't think did they have every car with a GPS?
I don't know. I think the majority of cars had the GPS, but only 418 or something had the kill switch. So only specific cops
Okay.
cars had the kill switch, including Proctor's.
It surprises me that only that they didn't have it on every car if they had it on some cars.
Yeah,
Okay.
yeah. Okay, so the next part is Proctor's texts. There have been some reports as far as maybe there's some racist things in there. Obviously, we know it's going to be bad. And then we get this announcement that Sergeant Goode, who testified in the first trial at length, did not testify in the second, which I always think is interesting. Like, why did Hank Brennan make these decisions as to who was a really big part of the first trial and not at all part of the second trial for the prosecution? What did he think about their credibility or how good of a witness they were? But Sergeant Goode has been put on paid leave while they have an investigation into allegations of misconduct that are connected to a former trooper from a different law enforcement agency. So they don't mention Proctor by name, but that's now the title that everybody knows about Proctor's former trooper, Michael Proctor of MSP. So it's directly connected with a former trooper from another law enforcement agency. And now this guy's put on administrative leave. People are speculating that it has to do with some of the text message conversations or interactions between Goode and Proctor. How unusual is that? And what are just kind of your first thoughts to hear about the fact that there is now an investigation into alleged misconduct bad enough to put him on paid leave? What do you think about that when you heard that?
Well, Good was Canton, right? He was a Canton.
Yes.
Yeah. Well, face it, when you deal with one of the worst law enforcement agencies in the country, I mean, Canton is just so bizarre. All the stuff we've heard in the retrial, you've just never heard from almost any other law enforcement agency that I know of. I mean, they were just rife with problems and corruption and incompetence over and over again. So if you're looking at generally across the country, doesn't happen very often that you've got that kind of a text between different law enforcement agencies where one agency is going to start disciplining somebody because of the text they had with another agency, because those texts don't even happen. It's a rare circumstance where you've got a guy investigating a case and he makes comments like Proctor made in those texts, and he sends them to his supervisor and all sorts of other people. It boggles my mind. It just really doesn't ever happen. But when it does happen, it actually should be disciplined, and they actually should get rid of cops that are like that and that deal with suspects like that, deal with investigations like that. So this guy, absolutely, if he participated in those texts with Proctor, he definitely should be disciplined.
Yes, but we know Yuri Buchanan was involved in some of the texts. We know Yuri Buchanan thumbs up some of the texts, and he's not under investigation for alleged misconduct. He's not put on paid leave. So I feel like it's got to be more than just being on a text chain or giving a thumbs up or sending an emoji, right? I mean, that logic would tell you it has to be more.
Well, logic would, but you have to wonder, why isn't he being disciplined as well?
Right.
I mean, there really should be some consequences to a law enforcement officer acting like this.
Well, he's been rehomed or whatever. Like he's in a different department now. I think Buchanan was one of the ones. I can't keep track at this point. There's just so many.
Oh, yeah.
All right. So the next document we're going to look at here is one that is just kind of simple. And the reason for it, the reason we're showing it is because you'll notice something is redacted on it. It is Michael Proctor's email that's redacted for privacy that he sent from one email to his state email. And, this would lead you to believe that Michael Proctor is using his personal email in a Rule 17 opposition, and he's sending it from his personal email to his state email, which, from my perspective, opens up now his personal email into being discoverable material. What do you think? A little over a year ago, somebody opened a bank account in my name, and I had to jump through all sorts of security hoops to prove I am who I am, to get it closed out, and it was miserable, but I was on notice that my information was out there. So I did a bunch of research trying to figure out who the best cybersecurity company was, and long before Aura was ever a sponsor of our channel, which they are today for this episode, that's who I found, Aura. They make it so easy for you to give them the information that you need for them to track. They give you reports of if your password has been used or leaked, or if you need to change your password. They'll give you examples of secure passwords, or you can pick your own. They make it so easy. Aura is all in one digital security. And if anything does happen, Aura includes $5 million in identity theft insurance protection. And they have US fraud experts ready to help 24/7. Try Aura for free for 14 days at aura.com/lawyeryouknow. In those 2 weeks, you'll discover where your data is being exposed and sold. I had to find out the hard way, so check this out so you don't have to.
Absolutely. If he did this once, how do we know he hasn't done it more than once? And we have a right to know. If he's done this, we have a right to know what he has sent. We have also a right to know what's in his personal email now, because maybe he has stuff in his personal email he did not send to his official email that would be relevant to the case. So we have a right to trace this, track it down, find out what's in his personal email. And again, find out, did he not send it to his official email? If he didn't, then that means there's more stuff in his personal email that we never saw.
Yeah, and that's the point, is if he's talking about this Karen Reed case, this Karen Reed investigation, or any case that, they're trying to get information that Proctor did, and they have proof that he wrote emails or worked on the case or was corresponding with witnesses or prosecutors or anybody from his personal email, they get to look through that. And it's not just like, no, trust me, this was the only one. We don't do that in the law. Like, you have to turn that over. And if you do have a privilege log or, reasons to keep certain things private, you've got to explain that. But could you think of anything worse than potentially having your personal email now mixed with work things as a cop? And now you get all that out. And this seems to be proof that if I'm a judge, I'm granting that. I'm allowing it now at this point because we have to find the truth.
Well, think of the stink that's been stirred up by national security cases, where you have people using their personal emails for national security information, and how shocking and frankly illegal that is to use your personal email for national security cases. So we've got a lot of situations where people aren't able to draw the line between their personal information and the official information and the official way they're supposed to conduct business.
Yeah, and usually they have to find out the hard way. And it's like, illegal or not, it's very annoying. It's wrong. It creates all sorts of problems for you and a lot of people in your life, right? I mean, it's like they're getting all these now looking through personal emails, and then, God forbid they find something else while they're looking through your personal emails. But yeah, I mean, it's a mess. It's horrible. And it also leads us to kind of the last section I want to talk about, which is potentially the biggest one. There have been some filings that prosecutors have turned over Proctor's cell phone information or things subject to the protective order in Karen Reed's case or the federal protective order in 19 different active criminal cases. First off, they're not necessarily done. It doesn't mean it's only 19, but it seems like it's at least 19. The fact that they're turning over information in 19 cases, what does that make you think as far as like what they're getting as they go through this stuff?
I may be wrong, but aren't they 19 murder cases or
I
just
don't know.
cases?
I just saw case names. I didn't look into each one.
I know there's one from 2017. I believe his name is Bell. And so it goes as far back as 2017, where people are trying to get all this information. Um, i- it's it's all, frankly, it's all relevant. They should turn it over. Um, it may not change the verdict. It may not change the case or have any impact on the case, but it definitely should be turned over. Because I think we said earlier, would it have changed the verdict if these things were revealed? The fact that someone is a racist, let's just say, Proctor made some comments, or the fact that he's a sexist. Uh, do those things impact a jury's verdict to such an extent that there's a doubt as to the sufficiency of the verdict? In most cases, no. In most
I
cases, there
think
has
it,
to be some direct relation.
I think it can, but it's not guaranteed. I think it can, depending on the rest of the context. Like, was he willing to do anything to get this person because of what they looked like or who they were? Was he willing to treat them like dirt and make sure that they got convicted because of what they looked like or who they were? I do think in certain contexts it can matter, but I don't think necessarily every single time somebody says something that's racist, if they're a cop or a prosecutor, that it means that the person is going to be not guilty at the end of the day. Clearly, I don't necessarily think that. But let me ask you a couple of the questions that like everybody has asked me in these videos, commenters, and Ted Daniel in the interview that I did with him. Uh, are the prosecutors only going to turn these over in cases where defense attorneys asked for it?
Well, they have a duty to turn it over, uh, and defense lawyers also should ask for them. There's two parts of this. Brady puts a duty on the prosecutors to turn it over. It's a Supreme Court case called Brady, and we've heard about it many times on these broadcasts. So there is a duty to turn it over. Brady also puts, and some people complain about this, but puts the onus on the prosecutors to be honest and to be the ministers of justice. And that's really the difference between prosecutors and defense lawyers. Prosecutors have this duty to make sure that there is a fair and honest trial because they control law enforcement, they control the disclosure of information, and they also are the ones that make the decision whether to prosecute someone or not. So all the power is in them. So they're supposed to be honest and they're supposed to review the information, and they have a responsibility not only to review the information in their office, but they also have a responsibility to review the information in law enforcement. So if law enforcement has something that should be turned over as Brady, the prosecutor has the responsibility to turn that over to the defense lawyer. Now, we're talking about two things in some of this information we've seen here. We're talking about Brady, and then we're also talking about normal discovery, stuff that is generally relevant to a case. That should be turned over as part of the regular discovery on a case. Brady, as we all know, is something that's inculpatory, something that will benefit the defense. Exculpatory, sorry.
Yeah.
Thank you. That will benefit the defense. Something that will allow for additional cross-examination or something that shows that your client is innocent. Prosecutors have a duty, and a lot of people don't really realize that. And unfortunately, a lot of prosecutors don't realize it, but they have that duty. So if they find something that's going to say your client is innocent, then they should turn it over, even though it may hurt them to turn it over. That is their job because they're the sworn officers of the court and they are the sworn ministers of justice. It has gone as high as there was a senator in Alaska convicted not too long ago. And it turns out the assistant United States attorney from the Department of Justice hid information from the lawyers of the senator. And that case was reversed and the entire case was thrown out, even though the senator got convicted for corruption. But it was all thrown out because the prosecutors hid information. The problem you have is if a prosecutor hides information, finding out that the prosecutor hid that information
Exactly.
is a very, very difficult burden. And that's why you also file motions for Brady information so that a judge can make an inquiry directly of the prosecutor. And, do you have this kind of information? Have you turned it over? And for a prosecutor to stand up in open court and say, oh, judge, we don't have that information, makes it doubly bad. And prosecutors can also get prosecuted for this because they're obstructing justice. So it's a very complex system that they developed with Brady, but they did put the onus on the prosecutors to make those decisions.
So basically, to boil that answer down into one sentence, defense attorneys, if you see Michael Proctor's name anywhere on your case, should be asking for this information. But whether or not they ask, the prosecutor still has the duty to turn it over.
Yes.
So the next question I keep getting asked is, What about cases that are already over? People have been convicted, but Michael Proctor was involved in those cases, or there are text messages about those cases. Do prosecutors have a duty to turn them over? So we'll start with that. And then the second part is, should defense attorneys or appellate attorneys in those cases request those documents to see if there's something that they can appeal with?
I think both of those questions are a yes. And I think number one, the prosecutor, if later on they discover something they didn't turn over, they should admit it. I've had situations, by the way, like that, where prosecutors, after a conviction, have actually admitted that they did not turn something over, or they found something that they didn't know about before, and they turned it over. And I actually had a motion for new trial granted, and because the prosecutors agreed, they didn't argue against it, saying, Judge, we agree that
It was
we should
bad
have a new
enough.
trial. Right. This is
Yeah.
bad enough, and we're sorry. And we made an honest mistake, and yes, the guy should get a new trial. And I've had that situation happen. So prosecutors have a duty to turn it over. The other is that, yes, you absolutely have a responsibility as a defense lawyer to ask for it. And every defense lawyer should ask for the Brady information. One of the things the courts have said, though, is your ask must be specific. You just can't say, I want all my Brady information. You got to say things like, in this case, Judge, we know there are text messages from Proctor that say this and this. So that's specific enough where the judge can make a ruling, because the prosecutors may say to themselves, there's nothing wrong with these text messages, so we're not going to turn them over. And then you have to go to a judge. Hey, judge, they have a duty to turn them over, and the judge can make a determination and order them to turn it over. So that's why you've got to file a motion, because again, some prosecutors may determine some things are not something that have to be turned over, not something that damages their case or goes to innocence of your client. That's a determination they've got to make, and sometimes you got to go to a judge.
Yeah, and the kind of analogy I've been giving is, if Proctor did say something racist, like, I hate Mr. Jones because he is a racial slur or whatever in the case, and he's already been convicted and he's in prison, they should turn that over. Probably not going to be enough to get him a new trial. But if he says, I know Mr. Jones didn't do this, but don't worry, I'm going to plant his DNA on the gun, that's going to be enough to be some new evidence that's going to get you a new trial. So it's got to be pretty egregious, usually in a big deal to get a new trial, if it's going to be in these Proctor texts for people that have already been convicted.
Right. Like an example is, let's say just an isolated, Proctor's isolated comments, sexist comments about Karen Reed, or looking for those certain kinds of photographs, or,
Yeah.
saying, she's hot, those kind of things. All right. You want to say, Judge, this guy is a sexist, he's against women, and, you yell and you scream about it, but it turns out your client's a guy. Well, a judge isn't going to say, well, man, Mr. Jones, that's going to have no effect on your case. The fact that he's a sexist, your client's a guy. So, those kind of things aren't going to make a difference. So a judge is not going to reverse the case based on that. There's got to be some connection between what you're trying to get in as Brady, trying to get your case reversed, and your client's specific facts and specific circumstances.
How far will this go? Let's say group chats, other law enforcement in there, Yuri Buchanan, whoever, Sergeant Goode, and them responding and saying things. Does this then open up the next ring to the cases that they investigated? If they're having, racist conversations about, we don't know what's in it. So like planting evidence, whatever. If there are other cops involved in those conversations, ratifying it, thumbs upping it, saying, yeah, I did that too, then the ring could continue to open potentially on all the cases that all these officers worked on.
It's almost impossible to predict all the different circumstances that could occur in what is said. And that's why you have judges to make those kind of determinations. Yes, it could. I can't say I can't. I can't say that they didn't say things bad enough that it could have impact on their credibility before the jury. We don't know. We're speculating, but yes, it absolutely could expand, and it could keep going. I mean, once you open up a can of worms like this, it gets broader and broader and broader, and everybody who touches it might end up getting, a little something on them, so that it's got to go, beyond just the small circle where you start.
If you're looking at these as a prosecutor, though, what is kind of your thought process as to how broad you're going to look at it, how far you're going to turn it over in cases and discover it based on it all depends on the context of the text messages, obviously. But at this point, with how much dirt is on this and how stinky all this is, and you don't want to get the stink on you, are you going to be pretty liberal with how you're discovering this to all these different cases, not just for Proctor, but for the other officers involved, not just for open cases, but closed cases? How broad are you looking at this as a prosecutor?
Well, again, not just in this case, but philosophically, I've always been very liberal in turning over Brady information. It's the safest way to do it. It's the honest way to do it. If you're a prosecutor, you're performing your duty by doing it. And if you don't do it, then you shouldn't be a prosecutor. You shouldn't be a minister of justice, is the way the courts have interpreted prosecutors. So yes, you turn everything over, let the chips fall where they may, and let the jury make the decision whether they're guilty or innocent. Prosecutors in good prosecution offices, it's not necessarily whether you win or lose a trial. If you tried a good case, you're going to lose some. Anybody who tries cases is going to lose some. The only, the guys who say I never lost a trial are guys that never tried a case. So you're going to win some, you're going to lose some. But if you do it right, you do it honest, you do a good job, that's really the best you can do. And that's what the people ask. The citizens of this country, that's what they ask of their prosecutors, is to do the best job they can. And then the juries, who are the citizens, make the determination of guilt or innocence.
Yeah. And I really think that it comes down to most of the time, not always, but most of the time, you do the right thing. You turn over the information you should. If you have decent cops that did a decent investigation and you're a good prosecutor, even if you turn over some of this and you have it in the case, if you have the right guy or gal, you go try the case and you can still win. You can still explain to the jury how this stuff happened. It doesn't mean you automatically lose. That's another question that I've got. We'll finish with this because there's as many documents as we could get into in an hour. So I'm sure you guys will keep sending them to me and we'll keep breaking them down as long as they're coming out and are relevant or interesting and you guys have questions. But do you think a bunch of guilty people are going to go free because of Michael Proctor's cell phone? That's another question I get. Obviously, it's possible, but what do you kind of think as far as probabilities?
Probable, no. There will be some, of course, but I think probably no, because if the facts are there to convict somebody, a jury is not going to find somebody not guilty because Proctor was such a lousy cop. We have lousy cops that testify all the time, that do bad investigations. But if the facts are there, the facts are there. And one of the things you tell clients all the time, you can't change the facts. The facts are there. The fact that this person might have been, again, a bad person, a dishonest person, or a racist person, whatever you want to call that particular fact, most jurors look at the facts, and most jurors, I have faith in the jury system. The jurors look beyond that and look at the facts of the case to determine whether someone is innocent or guilty.
Yeah, from my perspective too, I think that a lot of this comes down to thinking, because we're thinking about Karen. Most people's in their mind's eye, they're seeing Karen Reed, right? But take Lori Vallow, okay? Take all the evidence they had against Lori Vallow when they tried the case against her, all that circumstantial evidence and quick guilty verdicts on the worst of the worst crimes. Imagine that one of the cops had text messages where they're like, I was looking for nudes of Lori Vallow, or I hate Lori Vallow, I hate her lawyer, whatever. Would that have changed the verdict in that case? And I think the answer is probably not. I feel pretty confident it would not have changed the verdict in that case. It would have been wrong. It would be Brady. It should be discoverable. It would have come out in cross-examination. That cop would have looked like a jerk. That cop would have looked like a pig. But would it have really changed the outcome? And I think the answer is probably not. And so I think there's going to be a lot of cases like that, especially when you're talking about murder cases in Massachusetts. Like, there's going to be a lot of cases where the evidence is really damning, where I don't think these text messages are really going to flip it on its head.
I agree with you. Hey, the facts are the facts.
Yeah.
And if you've got good facts, it's not going to matter.
Right. So that's all we got for this episode. Thanks, Dad, for coming on, breaking this down.
Sure.
Like I said, you guys keep sending them to us. If you have more questions, we'll keep looking at them. Make sure you hit the like button on this video if you're watching on YouTube. And if you're listening to it on a podcast platform, please go give us a 5-star review. They help a ton. And I guess that's it. Until next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.